Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. A number of people have asked me some very pointed and fair questions in response to an article that I wrote recently about the U.S. Department of Homeland Security's social media posts on Christmas and how they violate the Establishment Clause. Now, in particular, one of our readers, a gentleman by the name of Ed Valdez, raised a very important set of questions that still to their essence basically boil down to what do we do about these constitutional violations? And that's the right instinct. Ed, shout out to you. It's one thing to sit around admiring a problem. It's another thing to propose a workable solution to that problem, and the latter is by far the preferred approach. So let's briefly recap what the original article actually said, because that matters for understanding the enforcement question. The core argument of my article was this. DHS's official Christmas post didn't just acknowledge a holiday. They crossed a constitutional line by affirming Christian theology. Statements like Christ is born, and more starkly by defining the American national identity in explicitly religious terms, saying, among other things, that Americans share a nation and a savior. Under long-standing Supreme Court precedent, the government is allowed to acknowledge religion in a cultural or historical sense. What's not allowed is to endorse religious doctrine or define civic belonging in sectarian terms. And that is exactly what happened with these DHS posts. Now, because these statements were issued by DHS in its official capacity, they constitute government speech. And government speech is constrained by the Establishment Clause. Now, the problem here isn't hurt feelings. The problem is that the government is aligning itself with a specific religious belief. And this is a key factor of Trumpism. The article went a step further and made the broader point that this kind of conduct is not accidental. It fits a larger pattern of normalizing unconstitutional executive behavior by pushing past established limits, seeing whether anyone responds, and letting violations of the Constitution become familiar before they become routine. That's the constitutional problem that we're dealing with here. With that foundation established, let's talk about what can actually be done about this. So the first question is, who has standing to challenge something like this? And this was a question that Ed asked directly. The answer is not just anybody who's offended. That's a common misconception. To bring a case in federal court, as Ed pointed out, you need to have Article 3 standing. That means there has to be a concrete, particularized injury, not just a disagreement with what the government said. Where Establishment Clause cases do get standing is when someone has direct, unwelcomed exposure to government religious endorsement in a context that they can't realistically avoid. And for the Department of Homeland Security, that matters a lot. The Department of Homeland Security is not a museum or a monument. It's a coercive gatekeeper agency. People who must interact with DHS, immigrants, asylum seekers, naturalization applicants, people in enforcement proceedings, are in a much stronger position to claim injury when the agency uses its official voice to signal a religious preference. That is the kind of plaintiff who could plausibly challenge these DHS social media posts in court. So the second question is, what kind of suit could they bring? A lot of people, even a lot of good attorneys, might instinctively think, okay, well, this is a civil rights issue, and then immediately jump to 42 United States Code, Section 1983. Section 1983 is the statute under which most civil rights cases are brought. But unfortunately, Section 1983 does not apply in this case. 1983 only applies to state actors, not the federal government. And the Department of Homeland Security is, of course, federal. Now, where it's a civil rights violation caused by a federal government actor, people might fall back on Bivens, the federal analog to 42 U.S.C. Section 1983. But the U.S. Supreme Court has recently gutted Bivens' actions. And in fact, Bivens' doctrine was never especially strong for First Amendment claims. Now, because 42 U.S.C. Section 1983 and Bivens' doctrine do not apply to a case like this, there isn't going to be any damages. So what kind of remedies are actually available? Well, here's the part that might surprise most people. There is no statute anywhere in the U.S. Code that says you may sue the federal government to stop unconstitutional conduct. Arguably, there should be, but there isn't. Instead, the available remedies come from Article 3 of the Constitution itself and the federal court's traditional equitable powers. When a federal officer acts unconstitutionally, they are not acting lawfully on behalf of the sovereign, meaning the United States of America. And courts of equity have the power to stop that ongoing unconstitutional conduct. But again, because there are no damages under Section 1983 or Bivens' doctrine, the real tools here are injunctive relief and declaratory relief. A court order telling the agency to stop what they're doing, and a declaration that the conduct is in fact violative of the U.S. Constitution. Again, however, the absence of damages is of practical concern. There's no money, there's no settlement, and there's not likely to be any sort of a contingency fee, which means it's very unlikely that a private attorney is going to take a case like this on contingency. There's nothing for that attorney to recover. And if their attorney doesn't recover, they don't get paid for their work. In practical terms, if somebody wanted to pursue a case like this, they would have to be able to pay the attorney by the hour, or in the alternative, a case like this would have to be brought by a nonprofit organization specifically formed to litigate constitutional issues in the public interest. The American Civil Liberties Union is a classic example. Now, this analysis does lead us to some kind of uncomfortable truths about American jurisprudence. The Constitution does not enforce itself. There's no automatic penalty for violating it. Enforcement largely depends on standing, courts, resources, and institutions willing to act, even when there is no financial upside. That's what the Trump administration is counting on. That's why normalization, like the kind that the Trump administration has engaged in lately, tends to work. If unconstitutional behavior is cheap to attempt and expensive to challenge, executives will push the limits. And if they don't get smacked down, they will push them even further. So, again, to Ed Valdez and everyone else who's asking, what do we do about this? This is the honest answer. You don't just sit around admiring the problem. You identify someone who has standing, you identify the correct remedies, and you recognize that enforcement requires resources, persistence, and institutional will. That's not pessimism, that's constitutional realism. Thank you once again to Ed Valdez and anybody else who asked for clarification on this issue. It is an important topic, and I hope to have more conversations like this. We live for those kinds of questions, and we get great video ideas out of your questions. Thanks again.